All right. Let me begin with a few administrative matters. We have to approve the minutes from the September 2nd, 2022 meeting. Will somebody please second approving the minutes?
Second.
Second. Is anybody opposed to approving the minutes? Good. Next, I want to share a brief legislative update. Governor Newsom signed into law all 5 of the committee recommendations that were enacted by the legislature just a few weeks ago. Thank you to him and his team, Senator Skinner, your team, and all the lawmakers and their staffs who passed these new laws, which I think are right in the heartland of what this committee is trying to do, which is to improve the penal code's efficacy, its understandability, reduce unnecessary incarceration and racial disparities, and improve public safety, all hopefully at the same time. They span from reducing the punishment from traffic offenses to improving mental health diversion, removing permanently incompetent people from death row, retroactive application of the Racial Justice Act. And in addition to this, there was another statute that was 2 other pieces of legislation that will increase data transparency in California and increase, and this was actually part of the budget, increase this committee's ability to collect data from the counties, which is super important. In addition, I think really an incredible achievement, again, with great work from Senator Skinner's staff, was the addition of $120 million expansion for enhanced reentry programs, expanding what's known as MCRP, or Men's Community Reentry Program, as an alternative to the last 2 years of incarceration. So we had another incredible year as we launch into making now our recommendations for the next legislative cycle. I just think, let's keep this momentum up, and it's terrific, and it's a tribute to everybody on this call, obviously, and a lot of staff folks, especially, yeah, Senator Skinner.
There were some other things in the budget that reflected discussions that our committee had. Some of the revisions to the victims program, for example, and a variety of other things. So we might, Tom, I can direct some of that to you. So maybe in our report, we can reference some of those things also.
Yeah, definitely. And I think that, as I speak to folks, we got a lot of positive feedback just yesterday from all corners of the spectrum on the issue, is that we're really gaining and have a good deal of respect among policymakers, lawmakers, from the governor's office down to stakeholders who are actually carrying out a lot of these policies on the ground. So again, it's a tremendous amount of work, led a lot by Tom. So thank you, Tom. And I guess this is my introduction or transition to let's get to work on our next set of recommendations. So
let's do it.
To tee this up a little bit for you, Tom, just a second, is right. The schedule going forward for the rest of the year is that we need to publish our recommendations. We're looking for, I believe, early December to disseminate our official report. And we need to give direction and formalize our recommendations to staff so that they can draft that report, and then we can approve it prior to that early December deadline. So our next committee hearing is when, Tom?
November 29th, the Tuesday after Thanksgiving.
So the Tuesday, by that time, a draft report will be circulated to everyone, and at that date, we will be voting on to adopt that report. What we are doing today, right now, is to vote on whether or not to adopt these recommendations, which will appear basically in bullet point form. Is that fair, Tom?
Yes, and our goal is to have that draft ready by the 18th of November, so the Friday before Thanksgiving. We know that holiday is in the middle, so we want to give it to you all, sufficiently in advance to really have a chance to take a look at it. And I think too, our goal is to include the bail and pretrial stuff we just spoke about, but obviously I think there might be more discussion on the 29th about tweaks to that, whereas the other recommendations, which we'll get into right now, are a little more cooked. So I just wanted to frame it that way too, that we're going to have that bail stuff in there as much as we can. And
none of the recommendations or the content really of the report should be that new. All of it, almost all of it, should have been will have been in our previous research memos and reflected in our conversations that have been happening earlier in the year.
Right. So what I want to do now is go through recommendations that we've discussed already from meetings earlier in the year. Then we'll turn to the topics that we looked at our meeting last month around traffic enforcement and assignment of counsel. So we'll hopefully we can get through the older ones quickly and then take a little bit longer with the older ones, and then we'll get a sense from you all of which ones we should include. And I think we're gonna do public comment before we do that, and then we'll be done. So hopefully we'll wrap things up shortly. Anyway, so these are the same slides that I distributed last week. So if you had a chance to look at those, these will look familiar. If you haven't, please ask any questions as we get underway. So we'll start with those previous proposals, as I said. So the first one is has to do with direct orders of restitution. So this is what a court orders after a conviction, and for the defendant to pay directly to the victim. But as we heard, the system is not working. It's not serving crime victims very well at all, if at all. Where victims are not getting money, or they're getting it in drips and drabs for years in ways that are just not helpful to the process. So the proposal that we talked about was that the state would pay restitution directly to the crime victim up to a certain amount. This is a model used in Vermont, and it would sever sort of the collection process from the payment to the victim. The victim wouldn't have to worry about getting the check for $3 every 8 months for 10 years or whatever the tempo would be. And then the state could decide, well, does it make sense to try to get essentially blood from a stone here, to try to get money from people who are not going to have it in a lot of cases? But it would sever those two things and put the victim's needs, satisfy those up front. And we would exclude corporations, basically non-people entities from it. So corporations, government entities. So this is really going to individual crime victims is the idea. We want to put, and when we write up the report, we hope to have a cap of either, somewhere between $5,000 and $10,000. We're still doing some data analysis with the California Policy Lab based on some data we got from the Berkeley Policy Advocacy Clinic to sort of see what the price tag for this might be. And we hope to have as much information about that as possible. That's the basic idea.
This will obviously cost the state money, but I think it's a good one. This is making victims whole. This is really would be nation. I mean, Vermont has this law in the books already, but really California would be leading the way into making victims whole. And I think it's something that we should do.
Okay, I mean, as long as there's some kind of reasonable cap, I think it's fine.
Yeah, what we hope to do is figure out if it was capped at say $5,000 or $7,500, what percentage of the orders would be covered by that. I hope we can do that. I'm not totally sure we can do it, but that's what we hope to include. Rick is becoming an accountant trying to figure this out, basically. Yeah. So he's going to have a CPA soon.
It's just bear in mind when you're going from one of the smallest states in the union to the biggest, the numbers increase in several magnitudes. Absolutely. And maybe this isn't the year to propose a big ongoing expenditure, but it seems like the right policy. So that's how we've been thinking about it. Okay, I'll move on to the next one unless there are any other questions. So this is another victims policy, and it's creating a victim's right to restorative justice. This is come from our favorite county, YOLO. It was an idea from, and our idea is different from what they proposed. I want to be clear about that in some important ways. But the seed of this idea came from DA Reisig in YOLO County. And the idea is if there is a restorative justice program that has been approved, and we can talk about what that would look like, and it would be, and the case is defined for it, meaning, it's not a murder case, though there's some discussion about that to be had as well. The victim has to be told about the program and given the choice to participate in it. So it would be up, the victim would be in the driver's seat about what they want to do. Of course, they could reject it, but it would be a way of centering restorative justice in the Penal Code and hopefully expanding its usage. And for some people, legitimizing it. It's obviously a legitimate practice, but I think some people would feel more comfortable if it was directly in the Penal Code. So, the 6 elements that are part of this, I won't go through all of them, but the idea is that they're community-based groups that, have been approved. And I think we could leave it up to the legislature to decide how that approval should work, whether it's the presiding judge of the court or the board of supervisors, but it shouldn't just be the prosecutor picks the programs. I think that's the one guide rail we'd want to set. It should be a more inclusive than that would necessarily entail. and that, should apply to a lot of offenses. I don't think we should necessarily list the offenses, but the idea is it shouldn't just be for graffiti cases. It should apply to some felonies and perhaps some violent felonies as well. But the idea is you give, if the program is there, you give the victim the choice to participate. And as we saw the data on this, it reduces recidivism in a significant way. There was a randomized control trial in San Francisco that Steve and Alyssa at the Policy Lab did. And the victim satisfaction is 90%. People who go through this tend to be extremely happy from the victim's point of view as well. So that's our restorative justice idea. Any questions, concerns about that one? All right, let's keep moving. Civil compromise, modernized civil compromise. So this is sort of a, I don't know, in the same universe as restorative justice in some ways, but there's an existing practice in the law, applies only to some misdemeanor cases, that if the victim comes to court and says, I've received satisfaction, that's the term in the Penal Code from 1872, the court has the discretion to dismiss the case. So it's basically the only way a victim can really drop charges, such as it were. So what we would say is, let's expand this to felony offenses, to, nonviolent, non-sex offense felonies, and also say, hey, satisfaction can be more than just paying money to someone. It might include community service or other things that the victim feels appropriate. So I think this is definitely sort of on a list of smaller ideas, but might be appropriate because it gives victims more input and control over a case. If it's appropriate, it might be especially appropriate for people who don't want to do a full-blown restorative justice experience, which can be, time and emotionally intensive in a way that some people may just not be interested in, but maybe they are also not interested in the traditional resolution as well. So we'd modernize civil compromise.
The only
All
thing
right.
that I would add
Yeah.
to this is a similar kind of notification to the victims, as this is an opportunity. Again, just to emphasize that the court would not be required to dismiss, right?
Correct. Right. It's still discretionary with the court.
But I think it should be required that victims are notified that this is a opportunity.
Sure. Okay, so that takes us to our competency ideas, competency to stand trial, sort of a deeper dive into a particular branch of the mental health issues that we always look at. So there's 3 recommendations around competency. They're kind of all interrelated in a way, but we've broken them out in 3 ways. So the biggest one is this one here, which is when a court determines someone is incompetent to stand trial, the court then has no discretion. They have to send that person to the state hospital, which might then contract out, if you're in Los Angeles, with Office of Diversion and Reentry, and hopefully with other places soon. But basically, they have to go through the state hospital to try to restore them to come back to court. But as Dr. Warburton told us, all that legally is required there is the person has to be put in a state where they can come back to court and the prosecution can continue. It's not explicitly aimed at long-term treatment. So what we would say in this recommendation is, okay, when the court finds someone's incompetent, instead of saying you have to go to the state hospital, let's decide if it makes sense, if it's in the interest of justice to restore you. And the reason to do that is it's not just a tremendous use of resources and there's litigation and, ongoing billions of dollars being spent on the state hospital process, but most of the people who come back from the state hospital get time served, probation, or a very short jail sentence. Very few actually go to prison. So it doesn't seem like, why don't we sort of cut to the chase on some of these issues? And there's no, as I said, there's no goal for long-term treatment for most of these folks. And, we saw numbers, and we'll have this data in the report about the number of people who come back incompetent with 17 or more arrests. I mean, a high number of arrests, it's going up every year. So it's really just a very unproductive cycle that we find ourselves in. So we'd say, okay, let's let the court decide, have some presumptions, if it's a nonviolent felony, if it's a wobbler. And we also, I think, extend the presumptions against restoration to some violent offenses, because we saw from the data that assault and robberies are the most common offenses charged in these cases. But as we know, assault and robbery, the definitions are so broad that sometimes it can be, the actual conduct might be more benign than the offense name suggests. But, we could specify the court would take into account the use of a weapon, injury cause, the likelihood and length of incarceration, and anything else relevant. But the idea is to get the court to actually consider what would be the most appropriate resolution instead of just having to go to the state hospital. So that was a mouthful. Oh, and the last thing I'd add is we'd also include that when the evaluation is done to determine competency, that the evaluator should also opine on whether the person would be suitable for diversion. Because if you're not going to be sent to the state hospital, you should, the court should order diversion or a conservatorship or one of these other interventions we have for folks who are in this situation. But I think diversion would be the most appropriate and hopefully common one. Okay, sorry, now I'm done. All right, I'll keep moving then. I'll take silence as a good sign.
And the judge, when he's making these determinations, does have reports, right, from one or two psychiatrists, psychologists.
Exactly, and that's why we'd add also to talk about the suitability for other interventions in that
Right,
report there.
I think that's a critical point. Right now that they have reports just on whether or not they're competent to stand trial and understand what's going on, what we would be adding is that, and here's the appropriate way to treat this person.
Yeah.
Got
Okay.
Yeah. Okay, another competency idea. So about 10% of the people who are found incompetent that go to the state hospital are not restored. And there's a 2-year time limit on that. And typically the reason they're not restored is because their mental health condition is such that it's impossible to restore them. Like you might have dementia or another organic disorder that no amount of medication or treatment is going to put you in a better place to come back to court. So we'd say, well, in addition, another thing the mental health evaluator needs to do is to opine on whether there's a likelihood the person could be restored, instead of going through the process of sending them to the state hospital and then having them sent back because it's just impossible to do anything. We would try to have the court make that determination at the outset. Some judges do this. There's not a clear avenue for it in the Penal Code, so it seems like an appropriate thing to make clear that judges should do. All right, I'll keep moving. Last competency one has to do with a timeline. So all the litigation around this issue is about timelines. And I know we had a lot of discussion about, do we just create a timeline for it to be broken, essentially? So we thought a lot about it. And the one we came up with, as you all might recall, is setting a 30-day timeline for that mental health evaluation to be done, which is sort of going to drive a lot of what else happens in the case. And I think as a result of the discussion last time and some discussion that Joy and I had with some other people too, that there, you can get it extended for good cause. Either side can ask for an extension. The defense may want it because they want to provide more records, or you can imagine all kinds of reasons why this shouldn't be totally set in stone. So we've added that in explicitly as part of the proposal.
Is that exception going to drive the rule?
That's always the concern for sure. But I think without it,
yeah, there's no
courts would give extensions anyway. So I'm not sure. Right. This is a Band-Aid fix, to be sure, to a much bigger issue. And I think that bigger idea is a better way to do it. But this seems like a worthwhile flag to plant in the ground and is consistent with what many other states do as well. And what a lot of counties are currently doing in California, but not everybody. All right. And that takes us to our frequent utilizers idea. So this arose out of the statistics that I think all of you have heard in different contexts. So that's typically a very small core group of people who are, frequently rearrested, going to the emergency room, using other local services. And there's lots of studies showing that to be true across our state, across the country. But then you don't see as often, what do people do with this data? So this proposal is sort of two parts, and it's entirely sort of a funding thing, which is to say, let's, fund the local agencies to talk to each other, link their data to find out who these frequently utilizers are. And then secondly, they actually have to do something with that data. You have to create a program that addresses them directly. And the few instances where that's been done have had tremendous success. There was the one I always cite is there was a program in San Diego that focused on this group of population, that an 80% reduction in emergency room admissions and I think rearrest rates. So it's the return on the investment, to use some of that lingo, is extremely high. And I think it was something the committee was interested in. Senator Skinner, do you have a question?
I wasn't at the committee where we were discussing this, and are there other actions that we could recommend that aren't only fund? I'm concerned that funding of any new thing is not going to be easy in the upcoming years. And it seems to me that since this is so much in a county or a city's interest because of the reduced costs they would experience from it, that maybe we have something like encourage, some alternatives or some additions to if we don't fund, what else might be there. Because if we only have it as fund and it doesn't happen, then it's like we've lost the value of what we're recommending here.
The only thing that comes to mind immediately is, nothing really significant, honestly. And we spoke to people about this. I think sometimes the agencies that want to do it have concerns about like sharing data and confidentiality and personal information, but I think actually those concerns tend to get worked out. So my first reaction would be to somehow ease the way to share data. I wouldn't really be strictly in the penal code necessarily, but I think that issue is a little bit illusory. I think places find ways to do it.
Well, just collecting them, and they don't always. So City of Oakland, I don't remember why or how they did it, but all of a sudden they realized that, and I don't know if they've done much about it, but that their 911 calls, there were just a couple of addresses for a huge percent of their 911 calls. And so they're, in terms of public safety response, emergency room, all of that came from this, a large percent came from this small handful. And any city that hasn't done that kind of deep dive, not just the county, then they're really missing an opportunity for savings. And if it's only listed as fund, then it's like it can't happen unless we fund it.
The other thing that's no, I agree. It really does seem to be, and the people we spoke with about it. Well, first of all, there is the MHSOAC is funding some counties to do this as part of the prop. I think it's 60. It's either 36 or 63. I think it's 63 funds. So places are doing it, but it is a lot of work to get the infrastructure in place. And then even once you sort of have those insights, like the ones you mentioned, what exactly are the next steps? I think is where you don't see as much activity. So I'm at a bit of a loss to know what else we could say aside from funded, because it seems to be once counties get into it, they really get into it, but we have to sort of nudge them to do it somehow. So I don't know if anyone else has any thoughts. Tax refund? So reverse funding?
I was
I
say,
don't know.
I'm sure the counties won't appreciate this comment, but it's like, what happens always is like, well, this cry of, well, we can't do that because we don't have the funding. When in fact, they're spending so much money because they haven't done it. And I, as a legislator, always resist that any recommendation we make has to be that we fund, that the legislature funds it.
Absolutely.
Senator Skinner, would it be helpful for the penal code to say to encourage counties to do it without offering the funding? Just to say counties should be encouraged to share this information, to
collect
studies.
it, it and share it. I mean, many aren't even collecting it. They have it, but they're not looking at it and analyzing it.
Yeah, so I wonder if just encouraging them to do it, and if including or developing language that says they're encouraged to do it without funding it would actually be impactful.
If it gives if it shows the benefits to doing it, yes. And maybe if it links to the other programs that we've set up now, like the care courts and other things, or even the alternative to 911 responses. There's a lot of things we've set up that we are funding that, can, that if they were doing this, they would be able to benefit from, that they may not be now without us having to directly fund this.
Well, I think we can try to work something up around that. I wonder how much our encouragement matters without anything behind it. But I do think raising this issue up is important, because the results that places have gotten really are, I mean, just shockingly good. So the more places that do it, the better. All right, well, we'll move on. And this actually takes us to the newer proposals. So we might, we're very close to the end, I'll put it that way, but these might go a little bit slower. So this was, these were written up in the memo that Rick did that we distributed last week as well. So, but we'll go through them here. So there's 4 of these that we'll go through quickly. 2 have to do with traffic enforcement, the first 2. So, you know, our last meeting, we went pretty deep into the issue of how police officers and other law enforcement essentially pull people over, and what they pull people over for, and who the people are that they pull over. And as other research has found across the country, there's racial disparities in who's stopped and what happens when they're stopped. So the idea is to say you can't pull someone over for a traffic offense unless it's safety related. And right now you can get pulled, you know, I'm just repeating what everyone knows. You can get pulled over for the most minor of traffic violation. And we would have a specific list in which I have here saying, don't pull people over for these. If you stop them for some other reason, for a speeding ticket, and you notice, you know, that their registration is out of order, you can write a ticket for it, but it shouldn't be the primary reason to pull someone over. It's sometimes called making them secondary offenses. So, you know, I think it's helpful to be as precise as we can here with citations to the vehicle code, though that makes you want to pull your hair out once you start looking at it. But just having that list and saying, you know, these are no longer appropriate reasons to pull someone over, which would, in addition to, you know, ending the impact directly on the people who are pulled over and the racial disparities we see there, also, I think, free up law enforcement resources to target, you know, more safety related offenses, because you're not doing so many these low level car stops.
And this is directly aimed at the idea of pretext stops, where people they're not being pulled over for these reasons. In any event, police officers don't have enough probable cause to pull them over for what they really worry that they're doing, but instead it's more of a dragnet situation where they're just pulling over anybody who has a broken taillight because they happen to be in a bad neighborhood, or in you know, they don't like the way that their car is or the color of their skin. So we want to stop that as much as we can.
Yes. So any thoughts, concerns about this one? It's relatively straightforward.
Are you going to mention the pilot project by LAPD as a footnote, or?
Certainly.
Definitely. And we hope to get updated information from them about it too. So we want to bring that as current as we can.
Right.
All right. Number 9. This is another traffic enforcement, but this has to do with what happens after the stop, and law enforcement asking people for consent to search, you know, which right now they can do for any reason. They don't have any reason to suspect they'll find something or there's a crime is taking place. And as we saw, the hit rates when they actually find something for these searches are very low. And in fact, there's also racial disparities in those hit rates and who is asked for consent in the first place. So the proposal here would be, instead of being able to ask anyone for consent to search at any time, you have to have reasonable suspicion, which is, you know, the lowest level of suspicion under the current framework for search and seizure, before you can ask to do that search. It would be a big change to the way the consent searches work, but we would limit it just to this traffic stop context, and would address some of the concerns we talked about in prohibiting the stops for those low-level non-safety offenses in the first place.
Or is the next one, you know, some kind of quasi-Miranda advice, or?
You know, we looked at that, and the research on it suggested that it was totally ineffective. That it's as helpful as Miranda, which is not extremely helpful.
Spill your guts, yeah.
Yeah, so just, you know, for reasons that we're all familiar with, the power dynamic is just so skewed that it's essentially impossible to overcome it. But it was something we investigated. And there was also the, you know, policy we heard about in Austin, Texas, where you have to get a supervisor's approval. And we thought this was actually less, I don't know, intrusive than that, perhaps.
Right.
And, you know, in some states, in addition to reasonable suspicion and probable cause, they have stuff lower than reasonable suspicion. it just seemed like it got too complicated, and was the last thing we should do is make this more complicated. But those are a few of the avenues that we explored before we hit on this idea. Okay, no other questions? Excellent. Number 10, almost there. So this is our appointment of counsel, which we've talked a little bit about today. So, there's great diversity in the state of California and how this issue is handled. In some places, you're not going to get a lawyer for many days, because even when you go to that arraignment, which has to be within 48 hours, but not including Sundays and weekends, you'll be told, okay, we'll get you a lawyer next time you come here. In other places, we heard about the Sacramento program yesterday, and in Santa Clara and some other places, public defenders' offices are finding people and contacting them shortly after arrest. We heard a wonderful presentation from Professor Heaton about the public safety impacts of having counsel earlier, that it actually reduces future arrests. It increases compliance with those conditions of release that we also spent a lot of time talking about. And obviously it leads to less detention and is a cost saver along those lines. So the core idea here is to require appointment of counsel promptly, but no later than 24 hours after arrest. And for those counties that do arraignment quicker than 24 hours, even sufficiently before arraignment that the lawyer can actually do something. They're not just doing a meet and greet at arraignment, and that situation that Ms. Sinnott described yesterday. So it's sort of two-pronged. No later than 24 hours, but those counties that are acting faster, you also have to provide counsel earlier. And part of that too is also some of the information sharing and notification stuff that we talked about, that we go through in A through D here, which is, presumption that if you're detained, if you're in jail, you're indigent and should, in the first instance, get appointed counsel, requiring the indigent counsel provider to be notified about everyone who's arrested shortly after they're arrested, so they have that list, can start preparing things, run conflicts, whatever they need to do. That's the first step to this.
Right, that came up yesterday as an important, so it's part of the bail reform things. I think that's really important.
Yeah,
We had a presentation on this from Santa Clara County, the public defender's office.
exactly.
Are there any extra costs associated with having these public defenders either based at the jail or on call to go visit people at the jail in advance of the arraignment?
I'm sure people will say there are, but if I'm sure that's how it'll be framed, but we're talking about lawyers that are going to be assigned anyway, and hopefully the cases are quicker to resolve.
Yeah, we're not asking people to do more work. It's only to do it early. It's the same amount of work. It's just a little bit earlier in the process. Now, I'm sure that does have some burden, but it shouldn't be significant.
Well, I tell you, it really moves the arraignment calendar a lot quicker, because we always wait for the public defender to interview the defendants in custody, and rather than starting at 8:30, they're not ready till 10 o'clock. So there's really a time savings in terms of court time when the lawyer has already talked to the client, instead of using the court time.
Right. And this is, another way too, to get that issue that you brought up, Senator Skinner, about those, even 23, 24 hours in jail. This helps. It may not get people out that quickly, but to the extent people are going to be released, anyway, you get a lawyer sooner, you can make those arguments more effectively earlier. It should lead to earlier release and safer release too. I mean, I think the public safety benefits were the thing that surprised me the most. As a former public defender, I was very glad to see that. But I'm sure they'll, anything we propose, somebody will tell us it costs $100 million. So we can't be always afraid of that. But this is a service that's supposed to be provided anyway. And there is litigation about it too. So there is that hovering in the background as well. And the rest of this is just, the things that we found important enough to specify that you have to have access to the detained people at the jail and in court, not while the judge is watching you, hopefully, Justice Moreno, but, sufficiently in advance to have a meaningful conversation. And I think part of this too is we heard about using social workers to do some of the information gathering, the informational interviewing, and some of the that piece of the work that you don't need a law degree to do, honestly, and that social workers are probably much better suited to do. So being explicit that those folks also have equal access, all members of the defense team. And then the last one, I think, is you know, in some counties, you know, prosecutors or courts will try to get people to plead guilty without a lawyer at their first appearance, and that just should be forbidden. And of course, would be taken care of if everyone has a lawyer before arraignment anyway. So those are the aspects of this. You know, there was this study that came out by a research project in Texas that ranked every state's, you know, first appearance program. Almost every state got a D or an F, and California got an F, and this is one of the reasons why. So it's an important thing to do. But it saved us a lot of work in doing the other state comparison, so we were glad to see it for that reason. Okay, our last one is something we haven't talked about, but it will go quick. So this is a project we've been working on as sort of part of our goal to simplify the penal code. So what we've done is counted how many felonies are there in California law, which I hadn't seen anyone do before. And we came out to about 1,400. And here's the distribution. So most of them are in the penal code, but only about half, you know. So when we talk about, you know, revising the penal code, we have to remember there's a lot of stuff that is in the penal code that is still a felony offense. And this is the distribution. So health and safety comes next, and then strong third finish, business and professions. I was surprised by that one, but there you go.
Yeah.
And then some of these at the bottom, you know, have one or two offenses. So this is just something I wanted to get a sense of the structure of the felony offenses in California. And the next step that we're doing is seeing, well, of these 1,400 offenses, how many have not resulted in a conviction within some set period of time. So we've been working with the California Policy Lab. This is very laborious work, but it's important, I think. And what I think we should do as part of our report is just provide a list. Look, here's the offenses no one's been convicted of within 5 years, 10 years. Legislature, if you think it's appropriate to address some of these, here's a good starting point. And I can tell you, and this will be in phases, you know, because we want to make sure we get it right. So our first phase, we limited ourselves to felonies that were not wobblers, that were in the penal code. That brought this list of 1,400 down to about 300. And in the last 5 years, a third of those have not had a conviction. So the numbers are high. Some of them are quite exotic. Possession of horse meat for human consumption. I guess we should be happy no one's been convicted of that. Train robbery.
We used to mention killing a sparrow or stealing avocados.
Right.
I mean, some of those can be quite serious.
Yeah, well, stealing avocados, it's considered a felony if it's $250. So it's, yeah, we have that. We're going to look at that one. And this is just no conviction. So, you know, we're going to put some more sophistication on this. Like, you know, if there's been one conviction or, you know, you can imagine different ways to do it, looking at misdemeanors, wobblers. We just wanted to do a first cut. So the proposal is that we include that list, and we'll just regularly update it as we expand the analysis. And it's a way for the legislature to decide if they want to repeal or otherwise address some of these offenses. Some of them don't make sense to repeal, like, you know, possession of an explosive device at a sports stadium, things like that probably makes sense to have on the books. And it's good we don't have convictions for that, I think. But it just, I don't think appropriate for us to go offense by offense and make a decision. So we'll provide that with the report, or maybe as an adjunct to the report or something. But just wanted to share some of those numbers and some of the initial conclusions with you all. So that's it. I'll stop sharing. I think we need to do public comment before we have a formal vote on which of those to include. And they've only have about 20 people in the audience, so maybe we can turn to that now, Mike, and wrap up.
Sure, I want to turn to that. I'm also mindful of some people's times. I know that they need to leave, and I want to make sure we can have everybody's participation. I'd like to limit public comment to the following motion, which is to approve the recommendations that was just presented by Tom, with two caveats. The first is that the issue regarding funding the data collection on the frequent users will continue to be ironed out between Tom, Senator Skinner, and her staff. And second is that with the understanding that the final wording and details on all of these recommendations will be presented in the draft report, which will be circulated prior to Thanksgiving, and which we will vote upon as a final report and recommendation in December. So that's the motion. We'll need to hear public comment on it, and then we'll vote. We've reached the time for public comment. For those listening via Zoom, to get in line to comment, please select the raise hand function. If you're calling in, please hit *9. Note this meeting is being recorded, that if you make a public comment, your name and phone number may be displayed as part of the recording. We'll take a minute now to see if anybody would like to make a public comment, and based on that, I'll see how much time we have for each comment. Please note that the committee also accepts public comment in writing. In fact, that's a preferred mode of communication, and the comment can be emailed to committee staff whose emails are on the committee webpage. All right, with that said, please get in line.
Let's get started. We've got one person, and folks can maybe line up for
I'd
another
like
minute.
to, okay.
I think this might be it.
All right, good.
So we've got Steve Munkeld from CACJ, unless it's a different Steve Munkeld.
Hi, Steve.
Hi, Steve Michael with California Attorneys for Criminal Justice, which I think.
You have two, just to set the stage, you have 2 minutes.
Steve, you can.
You go.
Okay, am I audible now?
Yes.
You are.
Okay, so I think you all know California Attorneys for Criminal Justice is the statewide association of criminal defense lawyers. As I understand the restriction here is to comment on the recommendations that were just laid out by Tom.
Correct.
Okay, so the only one I would like to comment on right now is the procedure for having counsel at the first court appearance.
Okay.
And I want to mention my personal experience at the beginning of my career in San Diego County, where, excuse me, where Defenders Incorporated had a contract to do the arraignment service at each of the courts in the county, felony and misdemeanor. And so that firm assigned an attorney to each arraignment calendar. That attorney was responsible for talking to both the out of custody and in custody people, hopefully before the start of the calendar, but as was mentioned, sometimes there were some delays because of the number of people or the time that it took for individuals. That attorney appearing at the arraignment was for the purpose of arraigning and for arguing for pretrial release if the person was in custody. They were not expected to be the appointed attorney for the entire case. It was a special assignment, basically. And I handled many felony and misdemeanor calendars in that role. They uniformly saved a great deal of time for the court, as was mentioned. You could have a arraignment calendar with 70 misdemeanor cases, and after consulting with an attorney, the court could get through all of them in well under an hour. That's just as an example. What this allowed was every single person who appeared at their arraignment, whether they were in or out of custody, had spoken to a lawyer. For the in custody people, the lawyer had taken some time to get information about their finances, their employment, their family situation, and their residence, so that they could argue effectively for pretrial release. Having had that experience at the beginning of my career, what has shocked me about the state of California as a whole, that very few places have provided that kind of attorney contact for the first appearance. Almost every place, the accused individual appears without counsel unless they've retained one. And the court then goes through the process of saying, well, we'll appoint an attorney for you and have you come back, which adds in delay, adds in cost for those people in custody, where you were just talking yesterday or receiving information yesterday about how critical even 23 hours in custody may be for turning a person's life upside down and increasing the probability of a future crime. Right. All of those delays are very significant. So that is a slightly different model for how to provide this kind of service than what you've outlined in your recommendations. And
let me jump in here for a second, because I think that a lot of the things that you said resonate with what we heard, especially yesterday. So I really do encourage you to write to Tom and our staff if you want to present more details on your recommendation. It's almost harder to do it by Zoom, candidly, but it does sound like you have interesting and important experience. I also want to make sure that everybody knows that we're not limiting public comment in general on these ideas. We've had multiple public comments on all of these ideas over the course of the entire year, and we'll have one more time an opportunity for public comment at our next committee hearing when these proposals are actually in writing, as opposed to just via Zoom.
And I'm limiting my comment to this one feature today because we have submitted a letter.
Terrific.
CACJ has submitted a letter about the 48-hour arraignment situation as well as the initial appointment of counsel situation. But I wanted to highlight this as a personal experience of a method that was quite effective in saving court time and representing people and avoiding some of the missteps that occur when a person appears before the court without advice.
Thank you.
Mike?
Yes, Senator Skinner.
So while we didn't discuss the exact proposal that Mr. Munkelt described, I think it mirrors much of, some of what we were considering. So I think it's worth it for, obviously, as you suggested, for him to send it in writing, but then for Tom to think about whether it's appropriate to incorporate when the report comes back to us and in terms of our final recommendations.
I agree wholeheartedly, and that goes with there's going to be more research and investigation between now and refinement. But obviously things are going to get even more and more refined every time we talk about this and think about it. And staff are continuing to work on all these reforms and proposals, I should say, between now and when they're distributed in the beginning of November or middle of November. So at this juncture, though, what we're trying to do is get agreement on the broad bullet points that we've discussed today so that staff can proceed and move forward. And then we will fine tune the details or approve the details or reject them at our next hearing on November 29th. So with that said, do I have somebody second the motion, which is to approve for staff development of the recommendations presented by Tom today, with the exception that Tom and Senator Skinner's staff and Senator Skinner will continue to work on the data collection proposal regarding frequent utilizers, and with the understanding that the final wording and details of all these proposals will be presented in the draft recommendation and report that will come out in November. Does anybody second that motion?
I'll second that.
Thanks. Senator Skinner, do you want to make an amendment?
Just only add that we did discuss it, and I think it's incorporated in your comments, but on those, there were various things on bail that we added some nuance to so that our final recommendation or final adoption might be different than what was presented. Some things incorporated and such or linked.
Yes, I should emphasize that I expect that they will be that the most refinement and fine tuning that we will do at our next hearing will be regarding bail, because it's the only one that we haven't discussed multiple times. All of these other ones we've discussed it multiple times. It's just the way the calendar works out. We only have one more. There has to be one subject that doesn't get the multiple treatment. So that one, but I think the advantage will be is that we'll have something in writing for us to look at. But I agree, we'll continue to hammer out and work on the details for the reform piece. For the bail piece. Does that all make sense? All right, I think there was a second from Judge Henderson. Is all in favor?
Aye.
Aye.
Any opposed? Thank you. Seems like no one's opposed. All right, all these recommendations, which really reflect, I should say, a year's worth of work by everyone. I mean, it was really staggering, even just hearing Tom run through the recommendations and remembering back all the way back the competency to stand trial and the victim's restitution issues that we discussed earlier in the year. It's really quite an accomplishment and so much work. All the presentations we've had, all the witnesses. I continue to be impressed and really grateful to everybody's work, especially Tom, Rick, and Joy, Natasha, and Laura and Lizzie, who really helped make all this come together. So thank you all. Our next meeting and the last of the year will be November 29th for review of the draft of the annual report and recommendations and what topics we will discuss next year. So thank you all. This is a busy day and a half. And I appreciate all of you. Thank you all very much. We're adjourned.
Okay,
Bye.
bye.